Hi, you're listening to LawBizNews, and I'm Glenn Duca.
Hi, you're also listening to Wes Ward. I'll be the co-host today on LawBizNews with Glenn Duca. Glenn, today we're discussing a very interesting topic, I think, which is commercial lease defaulting. Now, I know that in your practice you deal a lot with both sides of the fence in terms of from the tenant's perspective, but also from the landlord's perspective on this, and there's a million different scenarios that can sometimes happen, I'm sure. Probably a really, really good starting point is to look at what a default or a breach of a commercial agreement looks like in all the scenarios, so that then people know what we're talking about today. How does that sound?
Yeah, sure. A breach of a lease can happen in many ways. The most frequent way, Wes, is when there's a default in payment of the rent. That's the one you hear about the most. That's the one that it results in a lockout notice being stuck on the door and the changing of locks and so on. There are other types of defaults as well. You can have a tenant who has carried out unauthorized works at the leased premises. You could have a tenant who is using the premises for a use other than the permitted use. They're just a couple of examples. Lease defaults can be remedied as a rule, and generally if it's a retail lease, there really needs to be an opportunity for a remedy to take place. The landlord's got to afford the tenant that opportunity, right, as a rule.
So, you talk about remedy and giving the opportunity, in the payment issue, yeah? Like it'd be a bit harsh if they missed payment by 3 days and then the landlord comes down with a sledgehammer. Is that an issue, or has there got to be a remediation process built into your commercial agreements? That could be a significant sticking point.
Absolutely. Look, if it's a non-retail lease, a landlord can enter the premises typically if the rent's 1 day overdue.
Right.
If it's a retail lease, it's still incumbent upon a landlord to provide some notice period, and even then, if it's a non-retail lease, it's best practice to provide some sort of a notice period to a tenant before you go and enter. The reason for that is the tenant has the right to an action which is called relief against forfeiture.
Oh, okay.
So a tenant could, for example, it could be a florist, for instance, who has been locked out for non-payment of rent. The florist could apply to VCAT for relief against forfeiture. Now, if that tenant has not been a persistent defaulter in terms of non-payment of rent, and it's the first time that this has happened as well, there's a very high chance that the tenant's going to be able to have their lease restored.
Right. What sort of time frame is this? Like, if the landlord comes in with, right, get out, and then you go to VCAT, which is the governing body in all these property and commercial areas in Victoria. What sort of time frames are we talking? Is it like if they haven't paid over 45 days, or is it between 6 days or 3 months? Or,
Sure. Well, rent is due as and when it falls due, which is usually on the first of the month or whenever the lease says that it's due. Now, if you're a day late, it's a default. What generally happens is the landlord will issue a default notice and provide a period of 14 days to remedy the default. So there's that window of opportunity. And after that, that's when the lockouts come, if the landlord's so disposed to do it. Now, it doesn't always suit a landlord to lock out a tenant, but that's the exposure that the tenant faces, and it's a risk that needs to be taken seriously.
So would, after that 14-day period, be typical of a time frame when, so a landlord would go to VCAT? Is it normally that sort of trigger point after I'll give you 2 weeks to fix this up?
Yeah.
Is that normal, or would it be even further again? Like it's getting quite extenuating.
Well, once the landlord locks the tenant out, that's it from the landlord's point of view. They, unless they have, they need to sue the tenant for some other thing. They've normally got a security deposit there they can draw upon, and so on. But it's the tenant who has to move very quickly after the lockout I think if they want relief against forfeiture for a number of reasons, not least of which is practical, exactly, commercial reasons.
If you're a retailer.
Exactly. I mean, hello, you've been locked out of your shop. It's not good to be out of business for 3 or 4 weeks before you get around to doing something about it. So what you do, you go back and you get straight into VCAT and try to get it heard urgently.
Oh, okay, all right. Now, if we look at some other breaches, obviously we've covered the non-payment issue, but when you start looking at unauthorised works, it sounds like a very specific legal term. What can unauthorised works look like or take shape as?
Yeah, sure. Well, strictly speaking, all tenant fit-out needs to be approved by the landlord. And sometimes tenants don't understand this. They think, oh, well, I've done my initial fit-out, I get in there, I think I might make a few changes. Now, if they're internal changes, often a landlord may not even be bothered anyway or too fussed, provided the make good provisions of the lease are handled properly at the end of the lease. But the issue is that if there's some knock-on effect, for example, a tenant might carry out some works and do some damage to another part of the building, which affects another tenant.
Yes.
Now, you can imagine this is just a huge... it's a huge risk for the tenant because, I mean, litigation's going to follow or compensation's going to follow because the works are unauthorised. And this is why these clauses are in leases, because to help tenants not fall into default and to not cause problems that are ultimately going to cost them money as well as the landlord.
A lot more money, if they just cut off the power to the rest of the building or something like that.
Well, that's right. I mean, that's right. So, look, that's a default, strictly speaking. Now, if a landlord's looking to take a particular advantage, and sometimes a landlord is wanting to move on a tenant for various reasons, and they can look for breaches in a lease. So a tenant needs to be very sure that they're circumspect and that they're not ever in breach of their lease, because it may not be a problem now, but just because the landlord hasn't done anything about it straight away, they may do something about it later on, and it may be very difficult to remedy the breach.
Is that a typical issue? Like they may, the tenant may want something done, and then it comes a bit of an issue because they feel like the landlord's dragging their feet, or it is sort of technically part of the lease agreement to, I don't know, keep water services going hunky-dory or whatever, or maintenance issues or something like, you've got a leaking pipe in the ceiling of your showroom, and it's creating a nasty stain, and so it's not a deal breaker, but eventually it's going to drive the tenant nuts.
Well, yeah, absolutely. These are landlord responsibilities, and so just as the tenant has a responsibility to pay the rent and pay for the outgoings and do their bit and be circumspect, the landlord has an obligation to provide quiet enjoyment of the premises.
What do you call
quiet enjoyment?
Oh, that sounds like another legal phrase.
It does. It's from another age, isn't it? That term.
Yeah.
But it kind of it means what it sounds like.
Which is
that the tenant can quietly enjoy the premises without interruption of the landlord.
Right.
So the landlord has to provide services in all sorts of arguments, and there can be shades of grey as to who's done what. And for example, you can have a blocked toilet. Whose fault was it? If it's the tenant's fault, the tenant's got to fix it. There might be some problem in the pipes though, which then can become a structural issue, which isn't the tenant's fault. Right. And many a plumber has been called out on a Friday evening to run a camera down a pipe to try and work out who's right or wrong.
Oh, right. So ultimately the plumber would be the arbiter of that particular...
Potentially, yeah.
Right. Okay. So now, we've covered non-payment, but also other breach scenarios like unauthorised changes. If we start looking at permitted use, I think that sounds like another legal term.
Yes.
And I'm sure that's grey enough to imply all sorts of things, and it's probably worth uncollapsing what permitted use really means and how it applies to, I suppose, in respect to tenants more than anything.
Sure. Well, the permitted use is what the tenant is allowed to use the premises for. Now, often I see a lot of tenants come to me with new leases and they say, can you advise me in relation to this lease? And sometimes the permitted use is very narrow, and I always encourage them to try and get a much broader definition, because if they need to assign the lease later, it's far more advantageous, commercially advantageous, to be able to offer the lease to someone, for example, who needs an office rather than someone who is an accountant, rather than an accountant's office. So then you've got to try to deal with the landlord. If you want to assign, you've got to change the use and so on. Strictly speaking, the landlord doesn't, absolutely have to agree because the lease says that. So you want to have a broad permitted use. But where this can have impact in terms of default is if perhaps in a more unusual scenario where someone is going to use the premises, say it's a mechanic's premises, and they're using it as I'll use the example as a florist again. I mean, they're not the same use. Now, the landlord may not care in one sense, but that could have a knock-on effect, because if a landlord owns other properties nearby, or as part of a shopping centre in particular, it becomes very relevant. The permitted use will need to be strictly adhered to. So if the tenant steps outside of that, they can be in default. If they don't fix it, if they don't remedy it within the normal 14 days, they can lose their lease.
Right. So 14 days is a common standard window for breach remedy.
Sure.
Period.
Yeah.
Is that correct?
That's correct.
Yeah, right. Okay. When you're advising landlord clients, okay, and one of their tenants has fallen into breach, what do you advise? How do you tell them to go about remedying this?
All right. If I was acting for a tenant who's in default...
no, acting for a landlord.
Acting for a landlord, all right. A landlord has certain rights. We would serve a default notice on the tenant, and it's very important to serve a default notice quickly, and for each and every breach, if these breaches are happening at different times. Now, if there's a number of breaches at one time, you can put them all in the same default notice. Right. Alternatively, if a tenant is a persistent breacher of the lease, you want to make sure that you're serving default notices on the tenant consistently, because that actually has a very interesting knock-on effect, which not many people are aware of. Okay. That when it comes to the renewal of the lease for a further term, and in other words, when the tenant exercises their option, you can actually decline the tenant's request to renew. Because it's generally
can that impact their ability to exercise their option?
Absolutely, it does. Okay. But they have to be a persistent defaulter. Now, if they're a persistent defaulter, you've generally got to have it documented along the way. For example, if they miss the rent in month 3, issue a default notice. If they're missing it in month 4, default notice. If they're doing it again in month 7, default notice. But what a lot of landlords do is just nothing, and they think, they're just a little bit late. But if there's going to be a pattern, you're best to strike early and strike hard to set up that pattern. So then you can make an assessment as a landlord at the end of the term as to whether you really want these people to stay on. Now, there'll certainly be reasonable arguments to run if there's been persistent defaults to decline the tenant's exercise of the option. So that's what I'd recommend to a landlord. And then you've got from a tenant's perspective, they really have to comply. There's no other way. Now, if they can challenge the default notice, they can say, well, there really is no default, and I've certainly seen landlords issue default notices before, which are frankly without grounds and vexatious.
Oh, okay.
But it doesn't particularly help a tenant when you go to VCAT, because it's a no-cost jurisdiction in the retail leases list.
What?
It's a no-cost jurisdiction. Okay, yes. So in other words, if you have a retail lease dispute, it's virtually impossible to get costs awarded in your favour. And certainly
as a landlord.
Or a tenant.
Okay.
Like, it's just a no-cost jurisdiction. The system is designed to force the parties to come to an early resolution rather than to litigate. So when everyone's incurring legal costs, if they're incurring legal costs, and typically in the retail leasing list, that is the case, because it's complex law. So there's a disincentive to litigate. So to a tenant who's in default, best to fix it if you know and believe that it's true.
Right, because you could be playing to a strong point. From a tenant's point of view, it's in their interest, especially if they want to build up, say, a cafe or retail space and create goodwill in the spot. The more extensions, like 5 by 5 by 5 or whatever it is, 5 years, by 3 or 4 times, because I've got friends that do that, and part of their intellectual asset is we've got options for the next 20 years on this space. Yep. They might get in there, do an amazing job launching a new business, whether it's a cafe or a showroom or whatever it is, and then they know that their exit plan, say, in 3 or 4 years, knowing that the options go for 20, that'd be part of the value proposition in selling their business.
Absolutely,
yeah?
Absolutely.
So if a landlord's coming in and going, well, I've got the right to extinguish your options, that'd be a pretty heavy stick, or at least that's their negotiation point at the end. Do you see that at all, or it's already automatically calculated into all their thinking?
Yeah, look, if there's been persistent defaults, that'd be part of a potential buyer's due diligence, and if the lawyer's on the ball, they'd be looking for all of that type of thing, and you'd possibly make inquiries of the landlord. But yeah, look, that can be a problem, because theoretically there's been persistent defaults. Now, what you would want to do as an incoming purchaser and an assignee of the lease, you'd want to draw a line in the sand and make sure it's clear that the line's been drawn in the sand, and when you exercise the option, you're not going to be penalised. And it'd certainly be something that, if that was proposed by the landlord as a basis for not permitting the exercise of an option, that's something I'd recommend the incoming assignee would take to VCAT and argue their case, because they weren't the defaulter, it was the previous party.
Okay. Well, with regards to tenants, okay, you act for tenants as well,
yes,
presently and in the past.
Yes.
What should they be doing if they feel that they may be approaching a breach scenario, through no fault of their own, or whatever, rather than converge this, maelstrom and have to go to VCAT or whatever? Do you have clients that come to you going, I'm anticipating a breach coming up, or is it normally after the event has occurred? And Glenn, help me.
Yeah. Well, from a tenant's point of view, no news is normally good news. They mostly would approach a lawyer when something's happened. No one wants to spend the money on the lawyers.
Prevention's never spent on, isn't it?
No, that's right. So look, it's normally when they have a problem, there might be a default notice, or typically if they've been locked out, or they're about to be locked out, they're not quite sure how to remedy the breach. They're not quite sure, well, they want to remedy the breach and they know how, but they're not quite sure as to the approach they should take with the landlord, because it can be a very aggressive process, very intimidating, and people are just wanting to run their business. They might be a little bit behind on the rent, and then all of a sudden something's happened and things outside their control. So sometimes they come to us and they want us to try and manage that process.
Have you had to represent the little guy against very aggressive landlords?
Absolutely.
Yeah, right, because that can be quite intimidating.
Yeah, it can be, absolutely. And so we do a bit of that sort of work.
And even multinationals in that regard. I'm thinking massive shopping centres at this stage.
We've acted for a number of tenants in shopping centres.
Yeah, right. Okay. Oh, very good.
I won't say more than that.
Excellent. I saw the pause breath come in. That's excellent. Well, look, I think we've covered quite a lot of issues here today already. And if people wanted to explore more about getting your services and your help, what would they need to do?
Yes, well, they could go to our website, pcllawyers.com.au, or they can visit us here at LawBizNews.
And also your office in the CBD of Melbourne. You're located in the CBD. Excellent. What is the number that they could call you on?
Yeah, 1300 907 335.
Okay, you've been listening to another episode of LawBizNews. My name's Wes Ward, and you've been listening to expert advice from
Glenn Duker.
Bye for now.